So good afternoon everyone. A very warm welcome to all the participants joining us today for our webinar From Classroom to Courtroom. We are delighted to have all of you with us this afternoon. We'll begin in just a moment. So before we formally begin, let me ask you a question. As a law student, we spend years studying legal concepts, case laws, and procedures in classrooms. But have you ever wondered what actually happens when you step into a courtroom as a practicing advocate? How does litigation work in real life? And what skills are truly required beyond academic knowledge? And how students prepare themselves for a successful career in litigation? So I would like to hear all of your thoughts on this question. You guys can unmute yourself and answer the question. So I'm not receiving any response from you all. Can I repeat the question?
Oh yeah, please repeat.
Yeah. So have you ever wondered what actually happens when you step into a courtroom as a practicing advocate? How does litigation work in real life? What skills are truly required beyond academic knowledge? And how can students prepare themselves for a successful career in litigation?
I think the most important skills are reading comprehension and the ability to research and analytical solving.
Okay. Uh, so that's great opinion from your side. So today's webinar is designated to answer these questions. So this session will provide practical insight into courtroom practice, litigation skills, professional growth, and the transition from law school to legal practice. So today's webinar is organized by the Collective Council, a platform dedicated to bridging the gap between legal education and legal practice through practical learning initiatives, mentorship opportunities, skill-based programs, and career-focused training to help law students and young legal professionals and develop practical skills, gain industry exposure, and prepare themselves for a successful legal career is our main objective. So now it is my privilege to introduce our esteemed speaker for today's session. Advocate Himanshu Anand sir is a distinguished litigation practitioner and legal professional known for his practical courtroom experience and dedication towards mentoring aspiring lawyers. Through this professional journey, he has guided numerous students and young professionals on understanding real-world litigation and courtroom advocacy. His practical insights and first-hand experiences made him the ideal person to guide us today's topic from classroom to courtroom. On behalf of the Collective Council, I extend a warm welcome to you, sir. So, without any further delay, I would like to hand over the session to Advocate Himanshu Anand, sir. Over to you, sir.
Thank you, Kanak. Am I audible to everyone?
Yes, sir, you are audible.
Perfect. See, I want this session to be very interactive, so I wish everyone to switch on their cameras and mics if in case I'll ask some questions. But I want this session to be very interactive so that you can get through the technicalities, your doubts with respect to the litigation, because it's a very hard profession, I would say initially, because for a first generation, I am also a first generation lawyer. So I know how hard could be for you people to step into this profession, because after graduating from law, there are multiple spheres where you can go through and experience a lot of things, right? But litigation is something where until unless you don't have the dedication for it, it is hard to survive. So I want everyone's participation in that. And if anyone have any doubt with respect to how we should like put step into litigation, they can ask me. They can raise their hands into the chat box or directly in this session. So I believe all of you are the law students only, or is there any working professionals as well? See, this is for your benefit only, right? So I want your answers so that we can interact more efficiently and I can clear your doubts more efficiently. Otherwise, it is not a classroom, right? That's like just I deliver the lecture and you listen to it and then leave the class, right? All right. Sumatya Bose, all right, it's a first year. You are a first year law student. Very good. So you have interest in pursuing the career in litigation only, or you have something else in your mind as well? See, it will be very helpful if you'll answer me directly because it will be difficult for me to see the chats, right? So you can speak up. So in
Sorry, sir.
case,
I want to pursue only litigation and especially in criminal side.
all right, perfect. What about you, Shanvi, Jagriti, Dakshaja, Gungun, Ratul? Are you with me on the same page, guys? Or only one
Still
Sumatya is?
experimenting and have not decided yet.
All right, all right. See, this session basically why this collective council has taken this initiative so that they can make you believe that litigation is nothing but just a procedure and practice where you learn the law in the classroom and apply it in the courtrooms. So it is the session involves bridging the gap between studying law and applying into the court of law, right? Chotu Kumar, you are presenting the slide. You can turn the next slide. So, all right, since you all are law students, I believe you must have gone through with the sections, the case laws, and everything. I mean, this is what law school often teaches, right? You study the statutes, you study the case laws and judgments, academic understanding of law. Has any of you has ever gone to real courts, seen the proceedings, has done internship under some senior or anything? I mean, you have any exposure with respect to the how courtroom works? Any of you?
No, sir. I just went to the courtroom and just explored the background of what it looks like, but didn't see the procedure or haven't done any internship.
All right, all right. Shanvi, I got your answer that you are going to do an internship. See, it will be a whole new experience for you people because whatever you have learned in your law schools and going to learn in your law school, eventually you will apply it into the courtrooms. But still, the skills is very important. Even, see, I'll tell you very honestly. Let's suppose you know the sections, you know the case laws, you know the judgments, but not even a single like a judgment in the courtroom, right? They'll directly ask you the question, Mr. Counsel, please tell me how you are approaching this honorable court. What is your locus standi? How you have drafted the plaint? What are your facts and contentions? What are the reliefs you are seeking? So you should know what to write in your plaint, what to ask from the court, and how to ask it. Many of the clients come to me and ask, sir, this is my grievances. I have to file a case against this person. But you have to analyze, being a lawyer, see, you have to know whether the cause of action arises in favor of your client or not. You have to deal it very precisely. Until unless your client does not have any cause of action, he cannot go before the court. So, as a litigating lawyer, you know what to do, how to do, when to do. All right. So, in this session, of course, we'll be discussing courtroom exposures, drafting skills, procedural understanding, litigation strategy, client handling, and professional confidence. So, what is courtroom exposures? In courts, you see one side is for the plaintiff and complainant and the victim and the prosecutrix, and on the other side, the respondent, the defendant. So anyone can tell who all are they, whom we call prosecutrix, whom we call accused, whom we call defendant, whom we call respondent. When to use such terms? Any of you can respond? See, I want this very interactive. Otherwise, you'll not get to know the nuances in the litigation, right? It has to be very interactive. I want everyone to participate and say confidently. See, even if you will say wrong, I'm there to correct you. At least if you say, it will be inculcated in your mind throughout your life. So I want this session to be very interactive. So please say anything, say wrong. Mr. Akhilesh, Keshav, I'm only hearing Samatya's voice only. I want everyone's voice to be heard. Rashmi, Jagriti, please speak up. Say something. See, otherwise I'll just run through the PPT and you'll not understand anything out of it. Right? And if you want
I
me to
still
do so,
haven't joined the law school, but I can make some guesses.
yeah, of
I
course,
think
I want you to take random guesses so that I can correct you.
plaintiff are those who file the case, like the petitioners, and defendant who we have against them, then they will defend the case. Them.
Right, right. Very well. So we use the plaintiff term in a civil dispute. All right. So yes, Keshav has replied. It starts with filing. See, it is very difficult for me to read the chat also. Just a minute. I'll just go to the chat. Yes, huh. It starts with filing a claim in case of civil cases whose plaintiff and against whom it is made is respondent. Not respondent, but defendant. In civil disputes, we call it defendant. Right? Respondent and petitioners, sometimes people are use it interchangeably, but the real connotation for that is plaintiff is for the people, for the person who is approaching the court as a plaintiff as a in civil dispute, right? And against whom he is filing the case will be called as defendant, not the respondent, although people use it interchangeably. But respondent, when we file a petition, let's suppose if we file a writ petition. So in that scenario, the person will be a petitioner who is filing the writ petition, and the person will be responding will be the respondent, right? All right, Keshav. And apart from that, there is one accused. So expect this answer from you because you have an education towards criminal laws. So you must be an accuser.
Sorry, sir, I actually didn't research about it.
It's all right. It's all right. It's all right. I'll tell you. So in criminal cases, the one who is a victim is represented by the state. We call it as a prosecutrix. All right. And against whom the case is named, the crime will be called as an accused in criminal cases. So I guess I'm clear with which we use in the courtrooms. If accused, Chotu, why knowledge, understanding court procedures, strategic case handling, courtroom etiquette, practical abilities. So, see, the should know what handling the court procedures. So, I'll begin with how a case begins. Civil matters, we prefer to give a legal notice. Legal notice, and then it to be money notice, legal notice, and give them 15 days of time. Either it will be settled before approaching the court, and if the party does not reply or does not give any reply to your legal notice after 15 days to 1 month, you can file a case. So you draft the plaint. You put initially. I'll give you a little scenario. I'll give you a little the memo of parties. Now, plaintiff, so plaintiff's father's name, address, mobile number, email address, anything. Standing before me. And it entirely, you can say that it actually is the fate of the case. If your relief, or I mean, if your cause of action,
Where we should we
no, no,
draft
no,
a
no. In draft, I'm just giving you an overview of draft, right?
okay, sir.
In legal notice, you have to, of course, to whom you will address, to the defendant, right? So in legal notice also, you just the application you draft, right? To so the defendant, and in subject you write giving a legal notice to so and so person on behalf of our client so and so for amount of so and so. Then your factum begins. You have approached my financial assistance, and then my client has subsequently offered you financial assistance, and after on your this thing relying on your facts that you will pay back the money in 1 or 2 months, but you still haven't paid it, and then that is how you run the story, right?
Okay, sir.
Shavni has said something. Keshav Gupta, two types. No, Keshav, there are three types of jurisdiction. Yes, Karthik is right. Three types. Yes. Karthik, can you tell what three types of jurisdictions are? Karthik, are you there? Yes, pecuniary, very well. No, original and appeals are a jurisdiction of High Court. I am generally talking. See, original and appellate falls under the territorial itself, right? So there are majorly three types of jurisdiction. There is territorial, pecuniary, and subject matter. All right. So subject matter is also very important. So let's suppose if any civil judge deals with rent matters, so there is his subject matter. Yes, Shavni, right. So subject matter is what? Like if any judge deals with civil cases, the other judge deals with rent control cases, the other judge deals with diligent board BCS matters, some other deals with succession courts. So these falls under the subject matter purview. Then comes territorial. So territorial, anybody can tell what territorial is, as the name suggests?
So territorial jurisdiction means where the incident happened, and in this area we are filing the case.
Yes, the territories basically. So
Yes.
under uh, whom territory the cause of action arises. Let's suppose if I'm sitting in Dwarka and my property lies in Dwarka, and if I approach the court for declaration, suit of declaration, permanent injunction, possession, any whatsoever. So, but since my property lies in Dwarka, so the jurisdiction of Dwarka court will accrue, right? So the territorial is nothing but defines the territory. And then comes the pecuniary. So pecuniary is, anybody could tell what pecuniary is?
So, as per my knowledge, it's about the monetary value of the suit or the claim.
Perfect, perfect, Shanvi. You are absolutely right. So, if the subject matter in Delhi, I'll tell you, if the subject matter, the monetary relief we are seeking, let's suppose a 4 lakh. So the 4 lakh subject matter falls before the ADJ, that is additional district judge. And if it is less than 4 lakh, so it falls before the senior civil judge. So this pecuniary jurisdiction, as say we define it, right? So yes, So in the plaint itself, we have to tell the court that these are the factors. The suit we are filing is under the limitation. I'll discuss limitation also. What limitation is? Then the suit falls under the territorial jurisdiction of this honorable court. The court fee with respect to it has already fixed. So court fee is also very important. You will get to know the Court Fee Act. So we have to pay a little, very minimal cost and cost, you can say, or the court fee to the court. Let's suppose if the amount is of 4 lakh. So if we are seeking a recovery of 4 lakh, then the court fee will be of around this 6,400 somewhere. So this is how the pecuniary jurisdiction decides. This is how the court fee we ascertain in any civil dispute. In criminal, it's different. I'll discuss the criminal sphere also. So once you're done with your facts and everything in the plaint, then it is to be affirmed by the affidavit and subsequently the list of documents which are in your favor. So you support your claim with the evidences, right? So in terms of evidences, you support with the documents. Like you affix the documents. Let's suppose the chats you have affixed that on so and so date he has approached me. The bank transaction you have affixed stating that on so and so date I have transferred this much of amount and that is still pending. That's my legally recoverable debt. So these are all the parts of litigation, how you should draft the plaint, what should be in the plaint. So you'll get to know when you will step into the litigation. Why litigation demands more than legal knowledge? This is the reason. You will learn the law, but you will learn how to apply the law in the courtrooms only. Right? Let's move forward, Mr. Chotu. Somati, you have doubt, yeah, please. Shoot your doubt.
So I want to ask that how we define the monetary value of any suit when we are filing.
All right. So monetary value, let's suppose if you wish to recover 4 lakh rupees you have given to someone, right? So the monetary value of the suit will be 4 lakh. The amount, the relief you are seeking from the court is the valuation of the this suit. And let's suppose if we are filing a declaration suit for a property. So we have to ascertain the valuation of the property with respect to the circle rate which are being running in the present scenario. Then accordingly we file the court fee with respect to it, and that will be the pecuniary value of your suit. For the relief you are seeking will be your pecuniary value. Yes, Shavni, you were saying something?
Yeah, so I wanted to add on a little question of mine.
Yeah.
Oh, what if like we have had a lot of mental exhaustion and all these legal notices have been sent and it had been ignored? Then can we add a little monetary amount for that also?
Yes. See, whatever relief you are seeking from the court, you have to put extra court fee with respect to it. Let's suppose if I'm seeking 50,000 as a litigation reward in my favor, in plaintiff favor. So for that 50,000 also we have to pay extra court fee. So whatever we can seek relief, even in the legal notice itself, we can seek relief that yes, you should pay me the 15,000, 50,000 amount ranging. I mean, it depends how much amount you will quote in your legal notice. So you can demand from the defendant, but it entirely depends on the defendant itself whether he will pay or not. Right? But in court petitions also, you can mention it very clearly in this prayer clause, in the relief you are seeking from the court. So there is no bar to it. It's not that you just only, yeah. I guess I'm clear with that. All right. So common challenges faced by law students and fresh graduates. So these are the problems I would say, that lack of practical exposure, as I have already discussed. You know the law, but you don't know how to apply it, right? Uncertainty about litigation workflow. Litigation workflow is like at what stage you should do and what step you should take before the court. This is the workflow in litigations. As I told you earlier also, like the legal notice first we have to send. Then if the party does not settle the matter outside the court, then you file a case. For filing the case, I have given you a little skeleton structure for the plaint. Then subsequently you file it before the court. It will be listed before the court. Then the court will issue the notice to the defendant to settle the claim. So the defendant will come In 30 days, the limitation is very important in civil disputes. In 30 days only, the opposite party has to file their reply. You'll learn this in CPC. All right. So in 30 days, the written statement comes from the defendant. If you have any, let's suppose, statement to put in your claim, then you can file a replication to the written statement. Replication is nothing but a reply to the written statement. And once the written statement and replication comes on the record, then the issue will be framed by the court. So the court will frame the issue. Now, issue is very important. What are the issues? So issues is nothing but the relief you are seeking. So the court will put the onus. The onus is nothing but burden of proving something. So the court will shift the onus with respect to the issues that these are the onus I'm putting on the plaintiff to prove his case. Let's suppose if I'm seeking a recovery of 4 lakhs, so the onus will be on me that yes, I have given 4 lakh rupees to the defendant. These are the issues. So issue will be framed as whether the plaintiff has given 4 lakh rupees to the defendant, whether plaintiff is entitled to recover 4 lakhs from the defendant. These will be the issues will be framed by the court itself. Once the issues will be framed, the pleadings are complete. Now the trial begins. So once the pleading completes, the trial begins. So the trial begins when the cross-examination starts. So it begins with the plaintiff cross-examination. Plaintiff files his affidavit. In civil, it's basically go by the affidavit. So evidence by way of affidavit. It's just like a chief examination. So you tender all the documents, the documents which are in your support, and subsequently the other party will cross-examine and punch your case by questioning various type of leading questions and whatsoever, right? So he has the right to cross-examine the plaintiff at the first instance. After the evidence of plaintiff is concluded, the plaintiff get the opportunity to cross the defendant. So once the defendant this cross-examination is concluded, then the matter comes for the final arguments. So after hearing the final arguments, the court pronounces judgment. This is the workflow of the litigation. But in the meantime, you can file multiple applications pertaining to your relief. If let's suppose you need some injunction, so you can under Order 39 Rule 1 and 2, you can seek an injunction from the court. For that matter, you can file an application. So you can seek any relief during the proceedings also, and the court can pass interlocutory orders on that. All right, I'm clear on these matters. I am with you people, or you guys are with me? Are you understanding what I'm saying? Perfect. Yeah, good.
So
All
I have
right.
one more doubt.
Yes.
Is it necessary to send legal notice, or we can directly approach to court to summon defendant in favor of this case?
No. You have to file a legal notice. Otherwise, the court will see that you have not exhausted your lower remedies before coming to the court. So the court always refer the parties to settle the disputes before coming to the court, because eventually it will lessen the burden of the court, right?
Is it only for civil suit or criminal suit
Yes.
also?
In civil suits, it's important, but in criminal it is not. See, I'll tell you the procedure of criminal as well. So in criminal, all the things are done by the state, right? Anyone can tell me a little workflow of how criminal litigation goes? How the criminal litigation works? Any one of you, give it a random guess. I guess you are not aware of how criminal litigation works. So there are two types of criminal matters. One is entirely purely a criminal matter. The other ones are the quasi-criminal. So what quasi-criminals are? Quasi-criminals are those who has civil in nature, but the procedure is followed by the code of criminal procedure. So the nature is civil, but the procedure is of criminal. So these are the quasi-criminal. So I'll give you one or two examples, like domestic violence cases. These are purely in civil, but procedure goes by code of criminal procedure. So that falls under the purview of quasi-criminal. The other one is check bounce matter, negotiable instruments. You will get to know, because check bounce matters are very common in litigation. You get to know how negotiable instruments matter goes. It's very, I mean, easy to go. It has nothing to do with, I mean, you need not to use your brain into it particularly. So these two types are the quasi-criminal matters. Now, if we'll discuss about the pure criminal matters, so let's suppose if any offender commits any crime against anyone, so the state will book a FIR or a complaint, lodge a complaint or FIR against that perpetrator. So once the complaint is registered or the FIR registered, the police authorities and the enforcement bodies start investigating the matter. Once the investigation is concluded, the police officer files the charge sheet before the court. So now once the police files the charge sheet before the court, and then the matter is come before the court for the first time. Prior to that, the matter was in the hand of police officials only. So the investigation is the part of police officers. So once the charge sheet is filed by the police officers, the matter taken by the court take cognizance over it. So courts see whether there is actually a cognizable offense or not, whether there is any need to indulge in this matter or not. And once the court sees that yes, the other party has committed the crime, the court issues the notice to the accused, or notice means you can say that the summons. You can in criminal matters we usually use the term summon. So the court summons the accused appear before the court, and the arguments on charge happen. So once the arguments on charge concludes, the trial begins. So in civil, after framing of the issues, but in criminal, once the arguments on the charge surfaced by both the parties, the matter goes into trial. So the same, then the evidence of the complainant will begin. In criminal matters, there is no need to file the affidavit for it. So you have to, the PP will the PP will ask questions, not question, but the PP will chief examine you first. All right. So the PP will examine you, and that will be your examination in chief. Then subsequently, the other party will get the right to cross-examine, and the trial begins in the same way as happens in civil courts. Am I clear
And
with the criminal procedure?
yes, sir, and I have one
Yes,
more
Yes,
doubt.
sir.
After filing the charge sheet, the accused can give a petition for bail, or they can file after FIR is filed.
See, now a very interesting question. So, let's suppose FIR on rape is lodged against XYZ person, right? So rape is a very grievous offense. So the police immediately arrest the person, right? Because in such scenarios, the purpose of arresting any person is just just to secure his appearance, as well as the other party will not be able to tamper the evidences. This is the only reasons why anyone could get arrested, right? Until unless you could show the court that I have no indulgence in the matter and I'm nowhere in the position to tamper with the evidences. I am nowhere in the position to flee from the court or flee from the matter or investigation. I'll join the matter. The court will easily grant you bail or even not even arrest you. But in such scenarios, let's suppose if the matter is of rape, so definitely the police will come and arrest you at the first instance. What you can do is that you can seek an anticipatory bail. So anticipatory bail is nothing but a shield from the arrest, right? So let's suppose if any person has been booked under rape and FIR has been lodged against him, the police will either directly go to his residence and arrest him. And if the person has any intimation or has any intuition that he can get arrested, he can, even before filing of the FIR, can seek the anticipatory bail. So before of the FIR also and after the FIR also, anyone can seek the bail. So anticipatory bail is bail in anticipation. You are not yet arrested. So anticipatory bail says that in anticipation of getting arrested, you seek the bail. And then comes the regular bail. So once you will get arrested by the police officer, then you can seek the bail. You can file a bail before the consent court, either if we are talking about the rape matter. So the matter directly goes before the session. So you have to file the bail before the session court. And if your bail gets rejected, the High Court is there. And then, of course, through SLP, you can go to Supreme Court as well. So bail is something which usually take when you get arrested, but in cases where the matter is a bailable offense. So there are two types of matter. Before going into bail matters, I'll discuss what bailable and non-bailable offenses are. Anyone can tell what the bailable and non-bailable offenses are?
No idea.
Abhinav, Sumitya. There is one advocate also in this webinar, Ratul, Gunjan, Shanvi. Shanvi, can you tell what is bailable and non-bailable offenses are?
But I have no idea about this. Like, I have no idea about the criminal aspect as well.
All right.
So bailable offences are minor offences, and non-bailable offences are actually the offences such as greater than 3 years of punishment will be non-bailable offences, and police can arrest without warrant. That is non-bailable offences.
Right, right. So bailable offenses are generally the petty offenses on which the police have the authority to give you bail. POXO, non-bailable offense. Of course, POXO is non-bailable offense. Murder, rape, even cheating is non-bailable offense. Bailable where bail is an automatic right. Karthik, not an automatic right, but yes, in bailable offenses, the police has the power to give you a bail. You need not to file an application before the concerned court to seek the bail in bailable offenses, right? So the police officers, if let's suppose anyone commits a bailable offense, so the police will come and ask him, give him a notice of 41A to join the investigation. Whenever he'll come to join the investigation, the police eventually give him a bail, seeking the sureties from him, seeking the bail bonds on him. Okay?
I
So
have a question.
yes, Shanvi.
So, like, I've seen, like, yet having committed a very non-bailable kind of offense, yet people get bail.
Right. So
Then
even in
how is that?
rape cases and murder cases in POXO also,
Yes, sir.
people gets bail. So
Yes, sir.
bail, see, as I already told you, know, why we arrest the person? We
Yeah.
arrest the person so that he will not tamper the evidence. He will join the investigation, and he will abide by the terms and conditions put forth by the court. Right. So arresting any person is just to procure his appearance before the court to join the investigation and to join the trial. That's it. So in cases, let's suppose if the murder happens, right? So the police will go and arrest the person. He'll be in the custody. First, the police will seek the police custody. So there are two types of custody also: police custody and judicial custody. So police custody is where the police finds that yes, the person is required for the investigation and interrogation. He'll be eventually beneficial for us to dig out more evidences in the matter. So in such scenarios, the police seek PC. So usually the accused sent to the judicial custody. Judicial custody is nothing but a jail, actual jail. And police custody is keeping the accused in police station for investigation or interrogation purpose. Am I clear with that?
Yes,
Two
sir.
connotations? All right. So if anyone get arrested, so the investigation, let's suppose if the investigation is concluded, everything is concluded, and the police eventually file the charge sheet before the court. Now still the accused person is in custody. So what we'll do, we'll move an application, a bail application, regular bail application before the concerned court, stating that the investigation with respect to the person has been completed. The evidence is taken for the appropriate adjudication of the matter has already been concluded. So there is no point of keeping the accused person in custody because he's an under trial prisoner, right? So the Supreme Court and High Courts are very clear that bail is the right and jail is an exception. So why jail is an exception? Because you are eventually curtailing the fundamental right of that person. You are directly hitting the Article 21, right to liberty, right? So this is the reason why the bail has been given to the person who are under trials. So once the trial concludes and the person gets convicted, he'll be sent to the judicial custody. Then there is no provision for the bail. So the provision comes for the parole, which our babas are taking nowadays, right? Am I clear with all the legal things with criminal procedure, right? Let's
Yes,
move
sir.
forward because it's not lecture, but I have given you a brief lecture over the procedures. So this is you're going to learn in this course, right? So let's move further. Chotu, please. So the litigation accelerator focuses on litigation fundamental, practical drafting, what you should draft, what not should you should put. You cannot put any incriminating thing in your plaint, right? So let's suppose if you'll say that I had given 4 lakh rupees to defendant and he had given me 2 lakh rupees and now still I'm seeking a 4 lakh recovery. So some things has to be kept to ourselves only in drafting. Let them take a plea for that matter, because of course the defendant will take a plea either for a set off or counter claim. So you'll know what set off and counter claims are. That's a legal term we use in civil courts. It's under Order 8. If anybody has read CPC, it's under Order 8, Rule 8. All right, court procedures, the court procedure is nothing. The plaintiff stands in. See, you all are young students. I want to tell you very, very, very important thing for your benefit. Always practice before the trial court first. Never go for a fancy litigation. I have given a lectures to my interns and associates with respect to it, because nowadays what people are finding it fascinating that let's practice in high court and supreme courts. But honestly, I'm telling you, high court has a very limited practice, because high court's original jurisdiction is there. Trial court means is district court, subordinate courts. Yes. So Matya boss, yes. Trial court means the district courts. The exposure you will get in district courts now, there is uncompatible to the high courts and supreme courts. High courts and supreme courts finds fascinating. You'll find it very fascinating that yes, we argue before the high courts over the law, but you should know how facts to be put forth in a trial courts, right? So always pursue your career in district courts. Even I don't have much of a practice. I'm a first generation lawyer. I started my practice in 2020. It's been 6 years now. But still, my major practice lies in district court, because eventually your district court matters will take you to the high court and the supreme court. Until and unless you will not clear the lower pedestrian, I'll say, you will not know how you can approach the high court. High court is a court of law. Everybody knows that high court is a court of law and the trial courts are the court of facts, right? So in high court, usually where let's suppose if any judgments come by the lower court, and there is a thing, the law which has been ignored by the trial court. So you can approach the high court on the basis of law. The high court is not a trial court. There will be no trial in the high courts. There will be only pleadings. You will file an application. You will file a petition in high court. The respondent will come, give his reply, and the arguments will begin. There will be no trial, no evidences, nothing. So to learn the procedural aspect of litigation, you must go into the district courts first. Learn the nuances, learn how things go, how things flow, how litigation workflow, right? From scratch, you will learn everything. High Court and Supreme Court is nothing, but they are appellate authorities. They have original jurisdiction, right? The High Court has original jurisdiction where the subject matters is more than 2 crores. So you can directly approach the High Court in such scenarios. And the High Court usually, like a writ jurisdiction, is also an original jurisdiction of High Court, right? Then there are tribunals. So High Court is usually an appellate authority. It's not even a trial court. So I will recommend you guys to go through the subordinate courts first. So, introduction. See, the program focuses on litigation fundamentals, practical draftings, professional courtroom conducts, court procedures, case preparations, and real-world appreciation of legal principles. You will learn the law in the law school, but in courts, you will know how to apply that. Right? Moving forward, Chotu, turn the next slide. Yeah. So, what makes this program different? Practical learning over theoretical learning, understanding how litigation actually works, learning procedural workflows, developing professional litigation skills, applying legal concepts in practical situations, building confidence for litigation practice. So I guess I have given you a broad overview of how litigation works. So I don't think so that even slides will give more information than that. So go to the next slide. So what core areas will covered? The foundation of legal litigation practice, court structure and jurisdiction. So the court structure, I'll tell you how court structure works. So in criminal, there will be this courts. Now it has termed as judicial magistrate first class. Then comes the session court. Then comes the high court, and then the Supreme Court. In civil, the matter pertains to a peculiar jurisdiction. If the matter is lesser than the 4 lakhs, then the matter will go to senior civil judge, then the additional district judge, then the high court, and then the Supreme Court. These are the hierarchy and the court structure in the Indian law system we follow. Litigation workflows I've already discussed. Drafting essentials I've already discussed, right? What are the important points to be kept in the drafting, making the plaint? Facts has to be very clear. It has to be in a systematic manner. You cannot say anything in the plaint. You have to be very systematic, very organized. Then comes the jurisdiction part, then comes the limitation part, and the relief you are seeking. The cause of action. The cause of action is very important clause in this plaint. Until and unless your cause of action clause is not clear, the court will not take up your matter. This is the importance. This is how the cause of action and limitation is important for a plaint. So when your cause of action accrue is important, and how does it accrue is important to tell the court, right? So case preparation techniques, courtroom conduct and professional ethics. Courtroom conduct is like how you behave in courtrooms. We have to maintain the decorum in courtrooms. I always suggest my interns to not to use the cell phones in the courtroom. Reason being because sometimes judge gets offended. The lawyers can do because of course they have to chat with the clients. They have to give the updates to the clients. We have multiple clients and we have multiple cases in a single day, right? So there are certain etiquettes which every law students have to follow. And then practical insights from litigation practice I've already given. Move on to next slide. So the skills you will develop is legal analysis. So legal analysis is what? To appreciating the facts. As I told you, like let's suppose if a client comes and say that so-and-so person has slapped him and now he wishes to file a case against him. So what you can do? You can suggest that person that there are no civil remedies lie for you. You can approach the appropriate authority. There is police station. Go there, lodge it, and then let the police take the investigation further and let the matter comes in the court. Then we'll come into the matter and in the picture, right? So we know how to analysis the queries of your client. So you will get to know and will develop such skill set in this course. Moving forward, so to please turn, yeah. So who can join this course? This course is ideal for the law students, the fresh graduates, interns, judicial aspirants, young professionals, first generation lawyers. I'm a first generation lawyer. So this course will actually tell you like how you can put your step into litigation. It's very important to build clients, but how clients will be built, right? The fear which every first generation lawyer has in his mind is that how client will approach him. The client will approach you by your knowledge, by your skill set, and how you're performing in the court. I got a lot of clients by spreading word of mouth only. My clients, I got them favorable orders. They're spreading. See, this is the beauty of this profession, that you need not to brand yourself. You will yourself become a brand one day. Your things will spread across the nation and people will come and directly approach you and they'll pay you any amount, whatever you'll quote. Once he's coming by a reference or by word of mouth, right? So you'll get to know the learning outcomes would be. Next slide, Chotu. A clear understanding of litigation practice, better familiarity with procedural aspects of court, improved drafting awareness, greater confidence in handling litigation related tasks, and stronger practical understanding beyond textbooks. See, I'm not saying that learning law is not important. Learning law is very important because eventually then only you will be able to put that law before the court, right? So learning the law is also important. Go learn the judgments. I mean, not learn the judgments, but read the judgments. It will help you to understand law because judgment is the best textbook to learn laws. So I recommend everyone to read the judgments as much as you can. Then turn next slide. So these are things why you should join the school. Moving forward, this is about me. So as you know, I'm a practicing advocate. I have expertise in post training also. I have trained corporate clients. I provide post trainings to them. I'm a trademark attorney as well, and I'm presently associated with District Legal Services Authority. So, District Legal Services Authority, which provide free legal persons who are not in a capacity to approach the court. So, we are the government lawyers. The pay will come from the government, but we cannot charge our clients for that matter. All right. I guess I have cleared all the doubts with respect to the litigation. If anyone can have any with respect to how litigation should go, what you should take care of it, what steps you should take. They can ask any questions with respect to it. And I guess this is it. We call it a day then.
I have a question, but it's not about the litigation part.
Yes.
Sir, actually, I've just finished with my first BA LLB. I've not yet decided what to do, so I'm currently interested in all the three areas of the litigation, judicial, and court. And where, could you suggest cover that, and how can I be sure that I can go forward?
You're a LLB student, so I believe that studying laws as of now because
Yes, I
in BA
studied the contract and the
constitution from all out list you. I have also taken all the you can say मैंने भी घाट घाट का पानी पिया हुआ है. I'll tell you my story. So graduated my LLM, and at that time the COVID was going on. So there is the thing which is I mean, I feel like that this litigation thing I cannot to survive myself. I by the IT university. I was there as an assistant professor for 6 months. Okay, no, it's become very monotonous for me. I cannot put my steps in this thing, exposure to it. I start beginning everything. After that, I thought, let's go into the contract to be review. You're waiting the contracts. All the domains go to the litigation. Whatever, where you can find the things. In all the domains where I thought that I can fit in, but eventually I fit into the litigation. I find it very. I've coming in onto this, you will be using a that what I guess this is it. I guess, right?
Yes.
I hope I hope it was fruitful for you people. So now you can decide whether you wish to pursue the career in litigation or you want to go to the corporate or explore different domains. Because after law, you'll have a lot of domains available for you in the market. But I would recommend everyone to go into the litigation because that is why we have studied law. At least we should know how to apply the law, right? So it is a very it will be a very roller coaster ride for you if you will go into the litigation. And of course, I'll be there. I'll be in the market, right? Today or tomorrow we'll meet up. Probably there could be a situation where any of you and I, will be representing some clients against each other. So this is the beauty of this profession.
Excuse me, sir.
Yeah,
So are you
Can I ask
suggesting?
one more question?
yeah, yeah. Please, please.
I was asking that, like, what are the common mistakes all the law students who are freshly graduated or the freshers like usually make, which can be corrected and can make you stand out?
Hmm. The I already discussed this thing. The first thing, the law students usually commit mistakes after graduating from the law school, is to run behind the High Courts and the Supreme Court practice. This is the biggest mistake any law student could do. Never go to High Courts and Supreme Courts directly. You will not appreciate. I mean, eventually you will appreciate after some time that yes, how the writ petitions are going, how the appellate authorities, how the facts are being appreciated in the high courts. But to learn the law actually from the core, you should approach the subordinate courts first.
Thank you, sir. And one more question. Sorry, I'm
Yeah, yeah,
bothering you
it's
way
all
too
right, it's all
much.
right, it's all right. Please, please, please.
Yes, so like I'm starting with my internship like
Hmm.
this Monday. So like could you give me like advices which can be like making me stand out and make the other person think that I am actually knowledgeable about this? Like
Go
yes, not that.
learn, read the judgments. See, I'll tell you my first day of the internship when I
Yes,
was
sir.
in second year. So I mean, my senior, he tagged me with the clerk. He said, "You stay with the clerk because the things clerk can teach you will not be taught by the seniors. So always stick with the clerk. The clerk will know every nuances. What are the setbacks coming in filings? What will be the nuances? How to deal the registry in high courts? The registry is very particular. So if you will not be
Yes,
able
sir.
to clear the objections, the your matter will not be get listed. So the clerk will know. Clerk will know everything. What things to be keep in plaint. What things to be done while drafting our things and while scanning and making PDF and whatnot. So be humble. Read judgments. Stick to the clerk. Ask questions. That's all. That
Like,
would,
how could we like ask questions? Like, me being an introverted person, I barely make friends. Like, I don't understand how y'all make connections because it is very hard. I've seen like lawyers and judges being from introverted to very extroverted, and they are very outspoken, and they're like very great at speaking. Like, how did you make them changes?
see, also you have to put extra efforts by learning yourself, read the judgments. Reading the judgments will make your path more, enjoyable. I would say more confidence. It will bring more confidence in you, and that's all, I guess. But you
Okay,
can
thank you,
definitely,
sir.
but you can definitely ask queries to your seniors. Senior will appreciate if you'll put forth the genuine queries.
So what if that senior is very strict and they're like, what do I say, very arrogant kind of?
See, that depends from person to person. For that matter, I cannot say anything. But my interns are very happy from me. They, because I have a very this nature, because I'm coming from a first generation. I know how difficult it could be for a young generation,
Yes,
right?
sir.
So
Yes, sir.
I tell everyone, like, uh, even let's suppose if I'm drafting anything, so if I'm facing any problem, so I tell my intern or my associate that, see, this is the problem we are facing. We filed one writ petition in the High Court, so
Mm-hmm.
we got some objections in the from the registry. So these things I discussed with my interns and associates also, that these things can also be objected by the registry. So you must take care for that matter. So it depends on the senior also.
Yes, sir, definitely. Thank you, sir.
All right, no
So
problem.
I have a question too.
Yes, Nivedita.
As I told, I have just completed my 12th and I still have a lot of time before I join my law school next year. Do you think it will be beneficial for me to intern under some lawyer?
No, 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 no. First, learn the law. You should
Okay.
know what law are, what laws are, right? So without knowing anything about the law, you'll go to the court. You'll not be able to appreciate the facts what is been happening in the court. So you
Okay.
must know at least a little bit of it. And if you're preparing for law college or CLAT, so learn the basic laws. Let's go by the contracts, contract act, go by the constitution, go by the IPC. Now it has been changed to BNS and BNSS, CPC. Learn a little bit of
Uh,
it. Superficially, just grab the knowledge. Then you'll be able to appreciate what is happening in the court. Because nobody, even the layman out right now, you are a layman, right? So
yes.
laymen are not able to appreciate what has been happening in the court. So I would recommend you
I've
to at
been
least
taking
learn a little.
courses on these contract law and all.
Okay, okay. But not every proceedings is pertains to the contract law, right? So
Hmm.
there are multifaceted cases have been pending before the courts. So one is with respect to different thing, the other one is with respect to the different thing.
Okay.
I got queries. Just a minute. Let me go through the queries. Soumya, it's my question also, how to make connection in this field, in which year we should approach senior for internships. At least if you are a BLLB students, start interning after your second year, because you must know a little law before coming to the court, right? And to make connections, you can always use the LinkedIn. LinkedIn is the best platform to get connected with seniors, to get connected with persons who are coming from the same backgrounds or coming from the same domain. So LinkedIn is the best thing.
Excuse me, sir.
Yes.
Yeah, I'm being a troublemaker again, but can I ask a question?
Yeah, absolutely. This is for you people only.
Thank you, sir. Sir, I was like asking, like, I've seen, like, with my peers here, with my classmates, I feel like I'm very behind because they have been mooting. They are doing some kind of NGO internships, and they're always in some competition and they're winning the competition. I
Mm.
feel like I haven't done any moot courts. I don't have any moot competition experience. I haven't done any debates. I have not done any NGO internships. I feel very fallen behind. How do I feel to cope up? Like, how could I cope up and feel like better than them?
You need not to pop up with them, Shanvi. Even I, from in my law school, never did any moot competition, never did any debate, did not do any internship with the NGOs. I did internship with the lawyer, learned a little bit about the litigation, and came into the profession. It does not matter whether you have done the moot courts or not. Eventually,
Yes,
you'll
sir.
learn it in the
But
courts.
like, so like, if you do internships, if you do like, if you win competitions, you get a better recognition by the people who are
Yeah, you will
hiring
get
you.
connections. You will get better connections. That's there, but it
Yes,
does
sir.
not say that you are behind from them. So don't think like that.
Okay, sir. Thank you, sir.
It's all right, Chandler. Yes, I got another query from. Oh, just a minute. I'll be having much time next month. Should I attend the trial course like or some internships? Will be more beneficial? I'll be in second year. Go to courts, Gunjan. Go to courts. You will see. Even if you are going with bare hands in the court, you will learn something. At least a minimum law you will learn in a court. So if you have a free time, go to courts. Sit in the court. I always recommend my interns if our matter is coming late, but still I prefer them to go and sit in the court, observe the court, because the court is the best platform and best place to learn laws. You cannot learn the best law in your law schools, but in courts. Anyone?
गुड
No?
आफ्टरनून सर। सर मुझे ये पूछना था कि मैं एलएलबी थर्ड ईयर में हूँ अभी, तो
Yes.
लाइक एलएलबी एआईबी 21 के लिए तो मैं एलिजिबल नहीं हूँ, बट एआईबी 22 अगर दिसंबर में होता है तो उसके लिए फिर मैं एलिजिबल हो सकूंगी?
बीएल आप एलएलबी थर्ड ईयर में है,
हाँ जी।
तो एलएलबी थर्ड ईयर के तो आप एलिजिबल हो जाओगे। लास्ट सेमेस्टर अगर आप कर रहे हो, लास्ट सेमेस्टर के बाद विल बी एलिजिबल फॉर एआईबी।
ओके सर। सर एआईबी मतलब अपीयर होने से पहले बार काउंसिल वगैरह में रजिस्टर कराना मैंडेटरी
हाँ,
होगा?
यस, मैंडेटरी है।
ओके सर, थैंक यू।
ओके, आई गेस नाउ वी शुड कॉल इट अ डे नाउ।
So just two more questions we have in the chat box.
Okay, wait, let me see. First internship, can I go with civil or criminal? Path, see, internship, if you'll join any internship, so you will get to, you'll have an exposure of civil and criminal both. So you need not to, as a law student, you should not particularly, as of now, think about going into civil or criminal. You should learn each and every law as of now. Huh. So Matyabo senior said that to make you better, you should participate in moods and debates. But I have that fear of speaking in front of everyone. What should I do? Am I also for generation? There is no one for me to learn from. So Matya, it is not important that you should move to make your CV better. Law firm does not see whether you have. I mean, of course, it does see it, but it does not matter too much that whether you have done it or not. So I don't think so that it will matter on a longer run. If you will come to the courts, you will learn the procedures. You will know more law than the mooters who are doing moot competitions. Shall we sing? Will we get a certificate for the session? That the coordinators will tell. Gun, yeah, sure. I appreciate you a lot, sir. I'd like to have one more questions. I've been thinking about attending some online NGO internships as well. I'm not chasing stipend. I've been chasing experience skills. Yeah, Gungun, you are absolutely on a right path. Never go for money. This is for everyone. Don't run for money as of now. Even in my law school days, I did internships for free. I never charged any stipend. Even I didn't get any stipend. So, but now I guess you should chase the experience. You should chase the learning, and money will come later. You need not to worry about money because litigation will give you so much money. That's not an issue.
I guess we are done with this
All
questions.
right.
Thank you so much for insightful and engaging session, sir, today.
Thank you
And
for
I'm
being.
sure,
Yeah.
yes, sir, please continue.
Yeah, I'm saying that thank you for being so patient, paid audience.
Yes, of course.
I'm sure our participants now have much clearer understanding of how litigation functions in the practice and what it takes to build a successful career in the courtroom. So to help the law students, so we have developed this practical skills and the gaining of industrial exposure. So that is how accelerated program works. And we shared in the chat box the registration link for the accelerated program. So I request the students go through the websites so that you can see the accelerator program thoroughly. And as we come to the end of the today's session, I would like to extend our heartfelt gratitude to Advocate Himanshu Anand sir for taking the time to share his valuable
Thank you.
practical knowledge and the courtroom insights with all of us. Before we leave, we request to kindly fill the feedback form that will be shared in the WhatsApp group so that the certificates of the session will be prepared accordingly. And your feedback is greatly matters to us. And now let's take a virtual group photograph. I request all the participants to take a minute and on the cameras if you are comfortable. I request participants quickly turn on cameras.
Of course, I know it's Sunday, but still you can turn on your cameras. You must be
Yes,
lying in your bed, but it's all right. Nobody will judge you. Do it. Come on. You guys are law students. You should be confident about your face and your appearances.
yes, participants, I request you to kindly turn on. Yeah,
Very well.
thank yeah, thank you so much.
All right, then.
Yes, yes.
I'll take your leave, guys. Have a good
Yes, sir.
Sunday. Enjoy
Yes,
your
sir.
day.
Thank
Learn
Thank
you.
you,
something new every day.
Thank you, sir.
sir.
Okay. Bye
Have a
bye.
great day, evening ahead. Thank you. Bye bye.
Bye bye.